Hi everyone. Through this video, we are going to see the concept called the contract of legal aspects of business. Contract. An agreement which creates a legal obligations is a contract. So, what is mean by contract means it is an agreement. So, a contract means we need an two person that is called as an offerer and the offeree. So they will be having an agreement of selling a product and they will be having an agreement of getting a particular product. So that will be called as an obligations of agreement. So what a perfect contract means they will be having an legal obligations between them. So that will be called as an perfect contract. And then in definitions of the business contract, they will be coming under the section 2h. Section 2h of the Indian Contract Act 1872. It is defined as follows: that is, an agreement which is been enforceable by law is a contract. So enforceable by law means when we can go move out for the court of law will be called as an enforceable. So that is, we can put a case on some other persons, or we can just we can just get some availability of lawful and legal things through the court of law. So that is called as an enforceable. So, and contract must be in an legal obligations. When the contract is been fulfilling the legal obligations only, he can move out for the court of law. So that will be called as an perfect contract. And the next one is we have seen in definition of contract like a legal an agreement with a legal obligations. So what does agreement means? Section 2E of the Indian Contract Act, which defines as follows. So every promise and every set of promises forming consideration for each other is a contract. So an agreement means it is an perfect promises. So and some for each promise they will be having an counter promise. So counter promise means, example, if A is offering car for 50,000 means so, and counter promise means a person B called he will be accepting and he will be agreeing for paying 50,000 rupees for that particular car will be called as a will be called as an counter promise. Okay, so here when the agreement will be fulfilling is every promises and every set of promises forming a consideration for each other will be called as an agreement. And here what is consideration means, I said the example A will be offering car, no, so car is a consideration for B, and B will be offering 50,000 for the car. So B for B car for B car is a consideration, and for A 50,000 is a consideration. So that is an opposite of giving up for a particular product will be called as a consideration. And then a perfect agreement means offer plus acceptance will be called as an agreement. And the next one is, and it is a very important question, that is the essential elements of a valid contract. So, in Madras University syllabus, and it is a most important question. So, in legal aspects of business for BBA degree and in business law subject for BCom degree, it is very important topic. And without this question, some other case like by giving in 10 marks or by giving in 5 marks, no other question papers will be there, no. So you can say it as an it is in such an important topic. So the first elements of valid contract means what are the basic elements which will be need for a valid contract. So if an contract must be very valid means they must follow this following nine considerations, that is will be called as an nine elements. And then first one is offer and acceptance. So for a valid contract, the first thing you need to cover up an offer and acceptance. Offer means offering some particular thing will be called as an offer, and then acceptance means accepting a particular thing will be called as an acceptance. So for an valid contract, we need two-person, one must offer and one must accept. So without a two-person, we can't have an valid contract. So when an contract will be fulfilling means if a person X is selling his land for 3 lakhs, so that is called as an offer. When they will be having an acceptance means when a particular person is accepting for 3 lakhs and for getting that land means that is called as an acceptance. And then next one is intention to create a legal relation now. So for an valid contract, they need an legal relationship. So the persons who are entering into a contract, so the parties who is just entering into a contract must have an intention to create a legal relationship between the contracts. So when entering into a contract, it may he may be an offerer and he may be an acceptant person. The two persons must be have a motive to create an legal obligations. So the persons must be have an moral obligations, and they must have an social obligations. So the social and moral obligations must be followed by them. If they are not following means following such a social obligations or moral obligations means that is not an perfect contract. So that is an invalid contract. And then third subheading is lawful consideration. So we have seen in before slides itself, like what is consideration. So what is consideration means something in return will be called as an consideration. And then here for a valid contract we need an lawful consideration. So that is something in return means we can't give a pistol for in return, or we can't exchange for drugs in return. So a consideration must be in a legal terms. So if you're offering a something means some return must be in a legal form. Okay, so receiving something in return is consideration, and the promise in return must be lawful. The promised products or promised thing must be in an very legal thing. And then fourth one is capacity of parties. And capacity of parties, it is a most important thing for becoming and for completing the legal contract. So when the contract will be invalid means a parties two parties, he may offerer and acceptance person, that is agreement persons between them. So that persons must be have an obligations with an effective way for completing an contract. So the capacity of the parties means that the agreement must be competent to a contract. The agreement, the person who is just involving into a contract must be in an very competent way, and they should not have an contract with an incompetent person. If they are having an contract with the incompetent person means that won't be considered as an law enforceable by law. So that is they can't enforceable in a court of law. He can't reach up. And then what is incompetent means the incompetent mean minors, lunatics, drunkards, alien enemies, or disqualified for contract. And then like minors means those who are below 18. will be considered as an minus. Lunatics means that is like mentally who's not stable person will be called as an lunatics. A drunkard means always who is having the alcohol will be called as an drunkards. And alien enemies means for India, Pakistan is a alien enemy. So some countries will be having an enmity, or they won't be having any peaceful oriented things. So that is will be, that countries will be called as an alien enemies. So for a valid contract, you should not have any contract with the with our incomplete persons. And the next one is certainty and possibility of performance. And certainty and possibility of performance means a performance for entering into a contract must be very certain and very possible. That is, a performance must be a happening thing for entering into a contract, and that must be an possible things for entering into a contract. If a person is saying he will just sell his products on February 31st means or February 30 means so that is an impossible and uncertain things. So that will not be happen. Things will be called as an impossible things. So for an healthy performance in a valid contract, they should have all certain things and possible things to happen into a perfect performance of a valid contract. So the agreement to form contract must be certain. Performance of an agreement must be possible. So the performance for an agreement must be possible for entering into a contract. And the next one is legal formality. Yeah. Legal formality. A contract must be oral or in writing. When we call it as an valid contract means valid contract means they should fulfill the legal formalities. So final thing is completing the formalities for entering into a contract. So where the contract must be in oral or in writings, but for an effective and prescribed thing will be an writing things. So the contract required by law to be in writing, or the oral form of legal formalities means when we are having any miscommunications or any fraudulent things or sudden when we want to go to the court of law means we can't go to the court of law when we are not having unwritten formalities. Okay, and through this video, I hope you would have been known about the essentials of a valid contract. So, thank you.